All right, so in chapter 8, we're going to look at some issues, some factors that may happen to the contractual relationship. And those issues could be while the contract is being formed or could be during the contractual relationship. Most of them will be when the contract is formed. So those will be issues that even though the contract seems to be valid, legal, those issues, they affect the relationship, and they may cause consequences to that contractual relationship. So let's start. So first of all, we talk about misrepresentation. What is misrepresentation? It is a false statement. I offer my smartphone to you and I tell you it's a brand new one, but it's not. I've been using it for 2, 3, 4 years. So it's a false statement. It's a lie. Now, if you enter into the contract because of that lie, it means you were a victim of misrepresentation. Now, there are types of misrepresentation, and we need to look at them. So, first type of misrepresentation is innocent misrepresentation. Well, an innocent misrepresentation is the person making that misrepresentation, that false statement, believes it to be true. For example, I'm selling you my smartphone. It's an iPhone 12. You ask me if it's working well. And I say, yes, it's working well. Well, I'm using it now. Now, let's say 2 days later, you buy it. It goes off. It's not turning on anymore. And then you take to fixing company, and they tell you that the smartphone is broken, has an issue with the motherboard, or I don't know, something else. Well, I didn't know that. I'm not a technician, and I was using it. So yes, I lied to you, but I lied to you in an innocent way. I didn't know. So when this happens, you have only one remedy available, and the remedy is called rescission. What is rescission? Rescission is to put the parties to the contract back into their original position. So it's like canceling the contract. You return the smartphone to me, and I return you the money. But remember, I lied to you in an innocent way. I believed my statement was true, but it was not. It ended up that it was not. Now, if you discover that and you still want to keep the smartphone with you because they say that fixing will cost you very little and you made a good bargain, well, you are confirming, you are accepting the deal, even though you were a victim of an innocent misrepresentation. If that is the case, you are not entitled to rescission anymore. Or let's say before you take it to be fixed, the smartphone falls and is cracked, fully cracked. Well, because you would have to return the smartphone to me, but now it's fully cracked, you can't return it because it's impossible to restore. So in this second example, again, court would not restore, would not apply rescission. How do we summarize here? If you are a victim of an innocent misrepresentation and you want to have your money back, for example, act as soon as possible so that you avoid to cause any damages to whatever you bought, and also you avoid to confirm that transaction. Still, if you want that transaction, you can keep it, but only rescission is available, getting your money back. There's another type of misrepresentation that is the negligent one. Well, we already know what negligence is. It is when there's a duty of care, when that duty is breached, and then there's causation and there's damages. Well, in this case, the person that makes the false statement, they were careless. And it's usually an expert because they know they have a duty of care and they breached the duty. They acted below the standard. So if you go to Apple Store and then you say, "Hey, I need an iPad for a specific application." Do you know if this app works in the iPad? Well, if the salesperson who is knowledgeable about the iPad say yes, it does work, You buy it, but you end up not being able to using that app in the iPad. So you were a victim of a negligent misrepresentation. Well, it was not an innocent because they are an expert. They know what they are talking about. So they were negligent. They acted below the standard of care. So in this case, rescission is available. You can return the iPad and you can get back your money. But also, you can sue for damages in tort because they were negligent. So we say that for a negligent misrepresentation, there are two available remedies: rescission and damages. But remember, you can only sue for damages if you actually suffered the damages. If you haven't suffered any damages, you can't sue for those damages. Now, there's another type of misrepresentation that is the fraudulent misrepresentation. Well, this is the most serious one. Why? Because there's fraud, there's intention to lie. So the false statement was made, and the person who made it knew it was false, or deliberately told you the false statement, or they just didn't care. So, for example, you asked me if my battery is in full performance for my iPhone 12. And I know it's not because I checked the system. I went to Apple Store and they looked, they searched and they inspected the battery, and they said it's just on its, let's say, 60% capacity. So I know it's not, but I lied to you. I intentionally lied to you. So I lie in a fraudulent way. So if you buy the smartphone for me and then you can prove I intentionally lied to you, you can get your money back by returning the smartphone to me. So rescission is available on the top of damages. Again, if you suffer damages because you were a victim of a fraudulent misrepresentation, you can sue for rescission, breach of contract, and damages in tort. So, summarizing, false misrepresentation is this false statement, and you only enter into the contract because of the false statement. Because if you knew it was false, you wouldn't enter into the contract. And there's rescission available for all types, for innocent, for negligent, and for fraudulent misrepresentation. However, damages may be available only for negligent and fraudulent damages. Even if you suffer damages due to an innocent misrepresentation, they are not available. Okay, but they may be available for negligent misrepresentation and fraudulent misrepresentation. Are we good? That's what misrepresentation is. So you have a summary here. Question for you to practice. Okay, I see answers as A. And that's right. Well, that's a memorization question. So damages are not available for innocent misrepresentation. It may be available for fraudulent and negligent. And that's the case for B, C, D, and E. A is an innocent one, so damages are not available. So that's a straightforward question. If you remember, you would need to remember that damages are not available for innocent ones. All right, let's move on. Let's look at more serious issues. Now, a contract may be entered too because of a threat, a serious threat, usually threat of violence or to do something very seriously against the person. For example, um, you, I need to borrow money from you, and then you say, no, I don't want to borrow, I don't want to lend money to you, and I say, okay, if you don't lend me money, I'm gonna hit you, I'm gonna punch you, I'm gonna do something bad to you. And then for you to avoid those injuries, okay, you say, okay, fine, I'll enter into that loan agreement with you. Well, you didn't want to, but you only entered because of duress. So that's called duress. Duress is when there's this serious, sometimes physical, usually physical threat. And then because of that, you entered into the agreement. Now, when this happens, the contract is voidable. What is voidable? Voidable, remember from chapter 6, in principle, the contract is valid. However, at the discretion, at the option of the victim, so in this case, you can have this contract declared void in court. So you lent me $1,000 because you were a victim of duress. Because it's a voidable contract, if you don't want to do anything, the contract is valid. Hopefully, I pay you back. But if you want to bring this contract to court, showing to court that you were a victim of duress, then, and if you prove that, if the court is convinced you were a victim of duress, then the court will cancel the contract. You should get your money back, and the contract would be canceled. Okay, so that's duress. Now there's undue influence. Undue influence is not as serious as duress, but it's when a party exercises their pressure, and they are usually a dominant party, they are usually a stronger party, or they are a trusted person. So, for example, we clients, we trust our professionals, we trust our lawyers, we trust our accountants, we trust our doctors. So, if those professionals make use of their trust to abuse on us, then we are a victim of undue influence. Again, the contract here is voidable. The same thing as duress. If we want the victim, we may have the court declare it as void. If we don't, we just don't bother. Now, there's presumption here too. So in the same situation as we discussed in intention, when there's a social relationship or family relationship, there's a presumption of undue influence. In other words, when I sell my car to my daughter, it's presumed that I influenced her unduly. But that presumption is rebutted, can be rebutted. So it's now here. I thought it was in chapter 7, but it's here in chapter 8. So this presumption can be rebutted. And how do we rebut that presumption? The same way. My daughter needed a car. She paid a fair market value for the car, and she had an opportunity to seek independent legal advice. And the independent legal advice she received told her that no, she was not being abused of. She was not being unduly influenced. It was a legal, okay transaction. So then we would rebut that undue influence. Okay, so duress is this more serious, usually a threat, usually physical threat. And undue influence is this pressure from a party that is dominant or a party that is trusted. And because they are dominant or they enjoy the trust from the other party, they make use of that trust to influence the other party unduly. Now, unconscionability. Unconscionability is, sorry, just get some water here. Unconscionability is when a party takes advantage of the other party, but not because they have trust or they are dominant. It's just they take advantage. So, for example, my mom is not tech savvy, and let's say I offer my iPhone. No, not yeah, my mom, but not me. Someone else. Someone else offers my mom an iPhone 2, iPhone 2, very old, and tells her that no, it's an amazing phone, and I'm selling for $1,000. Well, no one would buy an iPhone 2, and it's not a collectible item. It's just an old phone, and pay $1,000 for that. No, they would pay $1,000 for an iPhone 15 or 14, a brand new one, but not an old one. So this is an unreasonable transaction. No one would enter into that transaction. Now, it's not common for individual parties, to be involved in unconscionability. This is more common for consumer transactions. Sometimes companies, they enter into unconscionable transactions with consumers. So consumers enter. For example, when we discussed about open box items. So let's say that Best Buy says that they are not liable if the laptop that is sold open box doesn't work. Well, who would buy a laptop that does not function as a laptop? Who would buy a laptop as a decoration item? No one. So if I bought a laptop and it didn't work, and then Best Buy would come to me and say, hey, no, but we said we're not liable. We told you upfront. Well, that is unconscionable. No one would enter into such transaction. That is not reasonable. Okay. So that's another example. Again, not so common, but still, those are some examples I can give you. What is the main difference between fraudulent and unconscionability? Well, fraudulent. If we talk about fraudulent misrepresentation, well, they are intentionally lying. So I ask them if this laptop is a brand new one, and they say yes, it's a brand new one, but it is not. So that's fraudulent. There's fraud. Unconscionability is taking advantage. I take advantage, and regardless if there's fraud or not, and in most cases there's no fraud, I'm just taking advantage. Like someone who's smart, and they're trying to sell an old smartphone to my mom, who is not a tech savvy person, and yeah, they make it because my mom, she just thinks it should be okay. So in a fraud, there's intention to deceive, intention to lie. Whereas in unconscionability, you're just taking advantage. You're taking advantage because you are smart, and the other person is not that smart. Does it make sense? Did I answer your question? All right, so that's unconscionability. Now, question for you. E. All right, so Joe threatens to smash Harry's car if Harry won't sell it to him. That's right. So it's a more serious threat. It's even a physical threat. So that's duress. Now tell me, Joe being a victim of duress, is the contract void or voidable? Voidable. The contract is voidable. So remember, this is important. Both for duress, I have made it bold here. Voidable. For undue influence, voidable too. Not void. Okay? Voidable. All right, so let's break again. 10 more minutes. I need to get some coffee I didn't get. Let's break, and then we'll continue on mistake. Okay, so we'll now talk about mistake. So we're talking about mistake is related to mistake in a contract. So it could be that, as I told you before, I was selling you my Lamborghini, but I thought my Lamborghini was in the parking lot. However, it was stolen. So I made a mistake when I made the offer. That's why we say mistake is an issue that relates to consensus as a requirement. Okay, it's not a mistake that, oh, I didn't know about this or I didn't. No, it's not about knowing. It's a mistake that is related to the subject matter or related to the terms of the contract. As it says there, it could be assumptions, could be terms. It's not ignorance. Ignorance means lack of knowledge. Oh, I didn't know, for example, I didn't know that killing someone is a criminal offense. Well, this is not a mistake. Ignorance of the law is not a valid mistake. Uh, so let's look at some types of mistake. And by the way, there are simple mistakes in the drafting, for example, that courts will allow to correct. So let's say parties aimed at 10,000, but there was a typo when drafting the contract and it was only 1,000. Well, if both parties confirm that, just a typo, courts would allow that correction. Now, there's this type of mistake that is called shared mistake. That's an important one. That's the Lamborghini example. So when both parties to the contract, they make the same mistake about the subject matter. So it's a fundamental mistake. It's a key mistake about the subject matter. So you bought my Lamborghini. I sold you my Lamborghini, but we both made a mistake, the same mistake about the Lamborghini, because the Lamborghini had been stolen or caught fire, and it was unknown to both of us. So this is the example of a shared mistake. So what are the court's remedies here? Well, courts will resign the contract. Contract will be canceled, and parties will be restored to their original positions. So if you had paid me, I would return you the money, and that's it. Can the parties make an amendment to fix the shared mistake? In principle, not, because the subject matter, the mistake was related to the subject matter. So, like in this case, the Lamborghini doesn't exist anymore. So there's no amendment to correct that. There could be an amendment if the mistake, for example, was a typo, was something that does not actually affect the main subject matter or is not the subject matter itself. Okay, it could be that, for example, there was a mistake, let's say, in the condition of the Lamborghini. Then, okay, the Lamborghini is still there. That is fine, and that could be corrected if both parties want. They can amend the contract. Remember that an amendment, a change in the contract, requires valid, fresh consideration, new consideration. That is okay. But if it's an issue that took place, so it's a mistake, and it's the same mistake and affected the subject matter, in principle, the contract is canceled. Okay? So that's what a shared mistake is. Now, there's mutual mistake. Mutual mistake is different because mutual mistake is related to a misunderstanding. Here, parties make a mistake about an issue, but in a different way. So, for example, parties believe, so we negotiated $10,000 because it's an American party and a Canadian party. So the American party thought it was 10,000 US dollars. And the Canadian party believed it was 10,000 Canadian dollars. So there's a misunderstanding here. It's a different understanding about a term, about a section, about a clause. So how do courts address this? Well, courts, they will apply the reasonable person test. what would a reasonable person test interpret from this? Would they interpret as 10,000 US or 10,000 Canadian dollars? And then courts will apply whichever is more reasonable. Now, it could be the case that both interpretations are reasonable, are okay. And if both are reasonable, both are okay, then the contract is void because there was an issue in the offer. The offeror meant US, for example, and the offeree accepted Canadian. So it means that the acceptance was not effective. There was a valid offer, but not an effective acceptance. So in this case, there's no consensus. In this case, the contract is void, is canceled, is not there anymore. Okay, so that's a mutual mistake and how it is solved in court. Now, the unilateral mistake. Well, a unilateral mistake is usually not helped by the courts. So when one party makes a mistake, let me give you an example. Remember the iPad example I gave you. I'm going to use the same example. But now I go to Apple Store and I don't ask any questions. I just buy an iPad because I believe the iPad will run the app that I need. I believe. And then I get home, I download the app. It doesn't work in the iPad. Well, I made a mistake. I didn't ask anyone. So in this case, courts, they don't help. It was a unilateral mistake. You made the mistake yourself. Now, how can you avoid this mistake? What should you have done to avoid this mistake? What do you think? The unilateral mistake. Come on, not a difficult question. I think I gave you the answer before. Ready? What do you mean by ready? Read the contract, terms and clauses. Yeah, this is a purchase contract. So I go to Apple and I buy the iPad. I don't see any issue in the contract itself. The issue is that I made a mistake because I believe the iPad would work for my purpose, but it does not. Reform the contract, not necessarily, because again, I made a mistake. My question is, how can I avoid the unilateral mistake? How can I avoid that I make the mistake myself and then courts will not help? Simple answer. Do not overthink. Okay, you should ask. You should talk to a salesperson. You should ask the seller. Because if they say that it does work and it ends up that it doesn't, it's going to be misrepresentation. It's going to be a negligent misrepresentation. And then the law will offer you a remedy, but not for a unilateral mistake. So we should ask. Understand what the product is for. It's fine. Yes, the better you understand the product, the better you are. But still, you can make a mistake yourself. You read, you misread, you understood wrongfully. So the best solution would be, or to avoid unilateral mistake, is to ask the salesperson. And they are knowledgeable about the product. They know much more, much better than you do. Then you would avoid unilateral mistake. And if there are any issues or any mistakes, you could rely on negligent misrepresentation. Okay? So that's unilateral mistake. Now, non est factum, this is a Latin expression, and it means it is not my act. Well, this is a defense in contract law. And this is a defense that is rarely successful. Why? Because this is a defense that the party is saying, hey, I signed it, but it was not my intention. I did not intend to sign this. Well, usually when we plea a defense like this, we were actually negligent. We didn't read well. we didn't, we were not diligent in reading the contract. But still, so that's why this is rarely effective. But it may be that the other party was so smart that even though we read at the best of our understanding and knowledge, we still signed something that we didn't mean to. So if this is the actual case, then this non-est factum defense can be possible. Let me give you an example. So when we go buy, not buy, when we go open a checking account, banking account, so the bank manager comes with a lot of papers for us to sign. And if they are smart enough to make us sign a loan agreement, even though we read, but we don't know bank products well, etc. So we read, but we were there to, we discussed about a banking account, checking account, but no loans. No, we don't. But if they were so smart that they made us sign a loan agreement, even though we didn't mean to, eventually we could raise this defense in court if they sue us for breach of the loan agreement. Now, again, just keep in mind that whenever the party raises this non-est factum defense, it's most likely that the other party, they will say, no, 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 they were actually negligent. They didn't read well, etc. So we need to prove that we were diligent, but they were too smart and made us sign something we didn't mean to, we didn't intend to. Okay, so that's an important aspect here. How can we prove that we received the seller's instructions or not? Yeah, remember, proving something is sometimes difficult, but not impossible. Let's say you go to a store, and when you go to a store, stores usually have camera recordings for safety. So eventually you can ask the store to release the recording of that day. And the recording would show you talking to a salesperson. Sometimes we only buy things when we ask. So there are certain products that we cannot just grab and pay. No, we need to ask. So that could also help. And also remember that judges, they do this on a daily basis. So when they are interviewing the plaintiff, when they are interviewing the defendant, they also get a sense if one is lying or not. Or sometimes, not always, but most of times. It could be that you had a witness with you. You had a friend, or there were people that saw you talking. So yes, it may be difficult to prove, but those are some types of proof or evidence you could try to make or bring to court. All right, so we went through those issues in contract law, so misrepresentation and the types, duress, undue influence, unconscionability, mistake, and then we talk about shared mistake, mutual mistake, that is misunderstanding, and then we just talked about unilateral mistake. So we need to add here some rules of interpretation. So whenever needed, courts, they will apply the reasonable person test. Courts can also use dictionaries if needed. They can use precedents, but they will try as much as they can to use or to have there to keep the intention of the party's intention to the contract. So if needed be, they will apply the reasonable person test. Now, we just stop here. Okay, so I was talking about interpreting contracts. So whenever needed, courts will apply the reasonable person test in an attempt to find the party's real intention, because courts don't want to give their own intention, their own understanding of the contract. No, they want to stick to the party's intention as much as they can. They may use precedents, they may use dictionaries, other things, and the reasonable person is a common test used in court. Now, there's this pero evidence rule. The pero evidence rule says that when there's a written agreement, when there's a contract in writing, courts will not allow external evidence. So external evidence, so no witnesses, no other documents, everything is in the contract, and they will interpret the contract. Okay, so that's the parallel evidence rule. There are some exceptions to the parallel evidence rule. It is here. It is mentioned to you here in the slides, but you don't need to focus on that. There are exceptions. I keep them here because the publisher gives them to us, but we won't be focusing on those exceptions. Now, the concept of privity of contract. What is this? Well, it's a simple concept. A contract only binds the parties to it. So if I buy coffee, the contract is between the coffee shop and myself. The contract does not bind you, does not bind the person who was behind me, does not bind my wife, my daughter. No, it's just between the parties to the contract. So that's what privity of contract is. Now, some exceptions to privity of contract, they are important. One is insurance, for example. So insurance, in an insurance contract, the beneficiary is also bound, or the beneficiary, they can enforce the contract. Imagine a life insurance contract. When the person passes away, the insured, if the beneficiary couldn't sue, if the insurance company denies, then the insurance company would be better off. So insurance companies and contract is an exception to privity of contract. So it's important to know what privity of contract is, which is a simple concept. Contract binds parties to it, but it's also important to at least remember one example, like insurance contract. So life insurance, beneficiaries, they can also enforce the contract, even though they were not a party to the contract. Some others here. So when we talk about novation, we'll talk about novation in a minute, but let's go for a question to test. Okay, I read B, D. So one afternoon, Adolf asked, no, not all. Okay. So the longer Adolf stayed on his job, the more he hated it. He thought his boss was too demanding. He especially disliked being reprimanded for being late. One afternoon, he was asked, okay, so Adolf was asked by a secretary to take a letter to his boss for signature. His boss had an eye, had an eye operation and was recuperating at home. Adolf got 2 signatures, one on the letter and one on a note promising to pay Adolf 1,000 in consideration for services rendered. So the boss was not careless, but couldn't read the papers. What plea or what defense, what argument could his boss use to avoid paying on the promissory note? What do you think? So he was deceived. He wasn't negligent. It's just because he had an issue with his eye, so he couldn't see well. So here is a defense. The only defense available here is non est factum. It's D. It's right. So non est factum. So you see, non est factum is rarely effective, but if you can prove you were not negligent, you were actually diligent, but the other person was really smart, then the courts may accept non est factum as a defense. All right, novation. So what is novation? Novation is when a party leaves the contract, or that party leaves and is replaced by another. So let's say you rent an apartment and then your apartment is sold. So your landlord will be replaced by a new landlord, by the buyer. The buyer will become the landlord, your landlord. So that's an example of novation. Novation is when one party is replaced by another. And because they are replaced, there will then be a new contract. So there's a new tenancy agreement there. When, let's say, when a company is purchased by another, usually if that company that is purchased, the company that is purchased, if that company is dissolved, so the new company will become the employer of the employees of the purchased company. So that's also novation. That's also an example of novation. So replacing one party to a contract to another, and then there's a new contract to that. All right, so now assignment. Assignment, I'll just tell you what it is in general terms, but you should not worry about assignment for the exam, okay? There won't be any questions there. So assignment is when we transfer a benefit, not an obligation, a benefit. So when you are in a contract, so let's say I'm selling a smartphone to someone, and I will get the payment in 30 days. So I give the smartphone, and now I have the benefit of being paid. Well, this benefit, this payment benefit, I can assign to someone I owe money to, if they accept. And I have to inform the debtor, the one that has to pay me in 30 days. So I come to the person I owe money to, and I say, hey, I have a payment, a credit that is due to me in 30 days, and I owe you the same amount. So do you accept this assignment? Can I give you this benefit as a payment of what I owe to you? So that's assignment. Companies, they do this when they need money from the bank. Companies say, hey, bank, these are all the sales we made. So we can assign to you our book of accounts, our receivables, if we don't repay you. So they get a loan and they transfer, they assign those benefits in case they are not repaid. But again, keep in mind that you can only assign, transfer a benefit, not an obligation. So here, there's this graph or figure to show what assignment is. So party A, so like my case, no, not my case, I'm party 2, I'm the second party. So I sold my smartphone to first party. So I am the creditor, I will get the money payment, and they will pay me. So they are the debtor. We are under contract A. Now I become an assignor because I assign my credit, my benefit to an assignee, someone who is interested. And eventually they will charge me some money, they will charge interest rate, they will charge a processing fee. That is okay. But I'm signing them the benefits under this contract. So that's what an assignment is. There are more details to assignment. There can be a statutory assignment. There are some things that cannot be assigned. But again, as I said, it's not going to be in your exam. So you don't need to focus on this. I just want to make sure you have a general understanding of what an assignment is. So I here want to give you news about what assignment is. But if you're interested, you want to read more, and you still have any questions, I'm more than your questions are more than welcome to me. You can ask me at any time. There's also involuntary assignment. Now, when we talk about negotiable instruments, because we're talking about benefits assignment, so it's also good to talk about negotiable instruments. What are they? A check is a negotiable instrument. A promissory note is a negotiable instrument. What is a promissory note? Well, we just had one here in the question. So a letter so a note promising to pay Adolf 1,000. So if I write a note promising to pay you a certain amount, this is a promissory note. And I give you the date, so I'll pay you 1,000 by a certain day with certain interest, etc. It's a promissory note. So it's an example of a negotiable instrument. Now, negotiable instruments, they can be freely passed to someone else. So let's say I write a promissory note to you. So I write a note promising to pay you 1,000 in 30 days because I owe you money. So you want me to write the promissory note to you. Then you can transfer that promissory note to someone else if you owe them money. The same as with a check. I write a check to you, payable to you. And then you can sign the check, you can endorse the check, and you can transfer the check to someone else. So with a negotiable instrument, whoever has the negotiable instrument in their hands, they can enforce payment. So I have a check. The check was passed to me by you. You received the check from someone who paid you, and you endorsed it to me because you owe me money. And then if I make a deposit of the check, and the check bounces back because that issuer of the check has no money, I can go after that person for a bounced check because it can be freely passed from one to the other. Again, there won't be negotiable instruments in your exam, but again, I'm just giving you news about these things here. All right, so summarizing chapter 8, we went through some issues with in the contractual relationship. We started with misrepresentation and the 3 types: innocent, negligent, and fraudulent. We looked at duress and undue influence. Remember that for those 2, duress and undue influence, the contract is voidable. We looked at unconscionability, mistake, and the types of mistakes, so shared mistake, mutual mistake, unilateral mistake. And then we just looked at privity of contract. It's important to know some exceptions to this concept of privity of contract, but knowing the concept itself is also important. We should know what privity of contract is. Any questions? Any comments?